Welcome to our virtual workshop. I'm Julia Barbosa Landua. I'm the Fiscal Sponsorship Manager and Grant Writer here at Fresh Arts. We are an arts service nonprofit in Houston, Texas. And I'm going to let our speaker, Erin Rodgers, introduce herself.
Hi, I'm Erin Rodgers. I'm an attorney at Rodgers Silvera. Some of you I recognize. I've worked with a few of you before, and I also used to work for Texas Accountants and Lawyers for the Arts. But anyway, my primary specialty is entertainment law, but I also do a lot of nonprofit work, and I love it. So I sort of live in that space between nonprofits and the arts. And I'm also an artist myself. I actually took yesterday off because I had too many Christmas gigs this weekend. So, but I'm a musician as well. So coming at it from that perspective too. So just a heads up, this particular presentation, I essentially Frankensteined a couple PowerPoints together from other presentations I've given on related topics. So there's a lot of slides in here, and some of them we will just touch on. So but I'm happy to share this information. And also I have a list of questions that Julia prepared, but I'm also happy to take questions at certain points. I think it will be smart to like get through certain chunks of information and then take questions that are relevant to that portion. So anyway, when we first spoke about what this presentation would be on, Julia mentioned that there was some interest in talking about different types of entities, how you can change from one to another. If you're going to be a nonprofit, what should you do first, etc. So this is a chart that I prepared years ago for a class that I was teaching at the Art Institute, RIP, and I've used it many times since then, but I think it's very helpful. So first, let me go through my questions on the left so you understand what I'm asking. Can I do it alone? Obviously, that's an obvious question. Do you need someone else to be working with you, or can you do this by yourself? Am I personally liable? So just so you're aware, the example that I typically give for this one, because I have a lot of musician clients, is imagine I'm playing a gig and I have a very heavy amp and it falls on someone's foot and breaks their foot. When they are angry about that and want to sue someone and they want to sue my band, am I personally on the hook or is my entity on the hook? So that's what that question is about. Do I have to file a separate tax return? We're going to talk a little bit about taxes, but I'm not an accountant. I recommend always having an accountant or consulting with somebody. I assume Fresh Arts probably has some resources for that. If not, I have some referrals. But in general, I can talk about taxes on a high level. So do you have to file a separate tax return, yes or no? And the ones where I have no starred, we'll get into that. It's more complicated. How much does it cost to set it up in Texas? So the only thing that I will note here is the DBA in partnership. That's also Harris County specific, but every county is going to be a similar price. Like Montgomery County, last time I did one there, I want to say it was $10 or $12. So it might vary a little, but 300 is the state price for those other things. And is it flexible? By which I mean, how much say do you have over how you want to run your company, and how much are you governed by whatever the state tells you? So, for example, in corporations, which includes C Corps and nonprofits, there's a lot more restriction from the state level about how you can operate that company, as opposed to like an LLC or a DBA, where you have a lot more flexibility about what choices you make and how you govern it. And we'll talk more about what that actually means as we get into this. But this chart's on page 1. Again, I'm happy for Julia to share this with you, so you can always come back to it. So I just want to start by answering one of the questions that was given to me from Julia, which is, if I eventually want to start a nonprofit, which of these things is the best way for me to later transition into that? And I would say, if you're going to start a nonprofit, just start a nonprofit. You can transition from a for-profit entity into a nonprofit entity, but it sort of depends on what your governance looks like to begin with. If it's just you and an LLC, a nonprofit has to have 3 members, so you're going to have to find more people, and it's going to be a lot of changes. A corporation, you may have shareholders involved whom are expecting a certain return on an investment, and then if you decide to transition to a nonprofit, you could be liable to them. So if you're going to start a nonprofit, I would say either just start the nonprofit corporation, which doesn't necessarily mean you have to file for exemption yet, or you could start with a DBA, which is the simplest thing. So DBA literally means just doing business as. It is not a separate company at all. It's just you saying, I am also doing business under this name. So for example, if you were a DJ and you performed as, I don't know, DJ Tanner, that would be your DBA. It's just you. You're just using this name, but you're still just you. The reason to do that, though, is it gives you an air of credibility. You can then get a tax ID in that name. You can set up a bank account in that name so that when people are going to pay you, you can use your business name for that, or also in contracts. It just makes you look more professional. It doesn't protect you from anything. It's still just you. It's just your bank account. It's your tax return. You're just saying, I'm also using this name for myself. It lasts for 10 years. You file it at the county level. So it is very simple to do, but doesn't really offer you any protection, but can be a good starting point when you just have a new idea starting out and you're not really concerned about liability or anything like that. So that's the easiest one. You can do this yourself. You can either go down to the courthouse or any of the annexes, and they will do that for you, or you can mail in the DBA form. It has to be notarized though, so sometimes it's easier to just go to the courthouse. But super simple, doesn't get you a lot, but you can at least set up a bank account and stuff. I sort of already mentioned all of that. If you want to see what DBAs already exist, DBAs, not to be confused with trademarks, you can have someone have the same DBA, especially in a different county. But if you want to search names, you can search those on Harris County Clerk's website. Partnerships are what they sound like, two or more people working together. There's nothing explicit you have to do to be a partnership. You just have to act like partners, which can actually be a big problem. So on one hand, it's nice because there's no formality involved in setting up a partnership inherently. I would recommend doing some things, but you don't have to. All you have to do is decide we're partners now and act like partners. The bad things about partnerships, though, is that each partner is liable for the actions of the others. So going back to my band example, if I'm not the one who drops the amp on somebody's foot, it's actually you, but you don't have any money and I do, I'm going to be responsible. They can come after me too individually as your partner, because we're all liable for anything that our partners do within the partnership, within reason. I mean, I'm oversimplifying, there are restrictions to that, but in general, that's the truth. So that's a scary thing about partnerships. Partners can file a DBA, and you just file a DBA with more than one person on it. And now you're a partnership and you get to reserve that name. I just want to talk a little bit more about this though, because again, partnerships make me nervous. And you might already be in one and you didn't mean to be, especially if you're working with other people right now. So my favorite story about partnerships is, I'm sure you're at least aware of 50 Shades of Grey, whether or not you've read one of the books or seen the movies. You don't have to admit that. But the company that was publishing the original 50 Shades of Grey, which was started out as Twilight fan fiction, was in Dallas. And it consisted of two women who lived in Dallas and then a third woman who lived in Australia. And as that book got more and more popular, as we all know, it was a huge bestseller at the time. The two women in Dallas started to wonder why no money was coming in. And the third woman in Australia kept saying, like, oh, it's just not that much. Oh, I don't know. I'll cut you all a check to make up for it while we're waiting on these checks. But they're watching this become a movie and become super successful, but they're not seeing any money. So finally, they sued her. Unfortunately, because she's in Australia, everything was in writing. And there's tons of emails. So they found out she had been collecting the checks. There was tons of money. She was getting it. And they said, well, we're a partnership. We should be splitting this money. And she was like, we're not partners. And they're like, here's 1,000 emails where she introduces herself and says, me and my partners. And then her defense in court, when they said, you know, you're a partnership, how do you argue that you're not a partnership? She's like, well, they're in Texas. People just say partner when they mean friend. It didn't work. So the court found they were partnership and the Dallas people got their money. So the point is, if you're working with people and you're acting like a business, like if someone reaches out to you to make a video and you say, yes, the two of us will be working together on this video under this name, essentially the court's going to say you're partners. So you should clean that up and figure out what the deal is going to be between you if you're going to do that. C Corps, I'm just going to touch on this one quickly. We've all heard of corporations. They're actually not that popular these days unless you're doing something that you're incorporating because you hope to have an IPO or to sell it or to have tons of investors. But for the most part, the sort of entities that I imagine most of you and me and my clients are doing are not C Corp type businesses. In all of my years of incorporating businesses, I probably do at least an LLC a week, and I've done 2 corporations. So that's just for some comparison. But it's important to understand a little bit about them. So the reason people originally liked corporations is that they are separate from you. So it's now a separate entity. You're personally not liable for anything anymore. The corporation is. So that if now if I drop my amp on somebody's foot, they're going to sue my corporation, and that might go bankrupt, but I'm not going to. Again, assuming I didn't throw it at somebody or something, that this is an accident. The shareholders and directors are protected from liability. And the thing that makes it not flexible, the thing that people don't like about it as much, is that you have to operate it based on the law as far as how division of assets goes. So a lot of times, especially in our arts types organizations, you might have one person who has the money and then one person who has the network or the skill or the equipment. So you might say, investor, you're putting in 90% of the money, but you couldn't be doing this but for my ability, knowledge, network, talent, reputation. So even though I'm only putting in 10% of the money, we're going to split everything 50-50. In a corporation, you can't do that. In a corporation, if you put in 90% of the money, you get 90% of the profit. And there are ways around that by being an employee or whatever else, but it's pretty strict as to that restriction. And again, a lot of times in our industries, that's not the way we want to do it. So it's just not the thing that most people are choosing. And also, I don't care about that right now. We'll come back to that. LLCs are the most popular one, and there's a reason why. So LLC stands for Limited Liability Company. It takes the best parts of the corporation and the best parts of a partnership and combines them. So corporations have that liability protection, partnerships don't. But partnerships, you can decide you're putting in 90% of the money, I'm putting in 10%, but we're going to split it 50-50. And maybe there's 3 of us and the other guy is not putting in any money. He's just working for us, but we all want to have a say in the vote. You can do whatever you want in a partnership as long as you decide that and put it in writing. It's up to you. So it's very flexible. So in an LLC, you have that liability protection from the corporation and the flexibility from the partnership in the same company. And that's why people like them so much. The other advantage of it is you can choose how you want to be taxed. So again, this is a super high level tax question. If you have more questions about this, I would hire an accountant. But partnerships are taxed at the individual level. So my partnership makes $100 and I have one partner. We each are reporting $50 on our tax return and paying taxes on that $50 that we earned. A corporation pays taxes as a corporation. So say the corporation makes $100, tax rate's 10%, I'm making that up. So the corporation pays $10 in tax, now there's 90. Now me and my other shareholder are reporting $45 each on our own tax return and paying taxes on that. So you are taxed twice, but there are times when that's better for you personally. Again, ask your accountant. But an LLC can choose if they want to be taxed as a corporation or as a partnership. So now I want to quickly go back to S Corps. What is an S Corp? What's the difference? You've probably heard of that. S Corps are limited to 100 shareholders and they all have to be US citizens, so they're smaller corporations. And they pay partnership taxes. But the real benefit to an S Corp is that if you're making enough money through your company to pay yourself a salary, you can get some tax benefits from that. So for example, a self-employed person pays an extra percentage of taxes that typically their employer would be covering for them. Let's say it's 6%. So as a self-employed person, you are automatically paying 6% more tax than someone who is an employee somewhere. So if this is your own company and I don't know, I'm a lawyer, let's go with that. So say I'm making $200,000 a year. I'm not, but let's say that that was happening. So if I'm making $200,000 a year, but I could argue that an average lawyer salary should be $60,000 a year, with an S Corp setup, I can take that first 60,000 as my salary, and then above and beyond that, the rest is a distribution and it's not taxed the same way. So I'm saving that 6%. That is a oversimplified way of explaining it, but The TLDR version is if you're making enough money in your LLC to pay yourself what is a reasonable salary in your field, you can't be like, my salary is $10,000 and I made $200,000. Then you can get some tax benefits from an S Corp. But S Corp is actually just a tax election. So you can have an LLC and file a document with the IRS to be taxed as an S Corp, and now you get that benefit. So that's another great thing about LLCs is you get all the stuff that you would get with any other type of entity, or the best parts of all of those things in one company. So how do you do that? It's $300 in Texas. That's our filing fee. You file the certificate of formation through the Secretary of State's office. You can file by mail, it's lower. If you do it online, it actually only takes about a day, sometimes less. If you file it in the morning, you might even be an LLC by the time the office closes. So it's very fast in Texas. We're super on top of that. We do not have ongoing filing requirements as far as paying taxes go. So in some states, it's cheaper to set up your LLC to start with, but then every year you have to pay $100 or $150 to keep it going. We do not have that. I think I have a slide. Okay, we'll come back to that. We do have to file an annual report, which is the public information report, but we don't have any taxes until you hit $2.47 million. So until you're making $2.47 million in your company, you don't owe anything else to Texas. So it's actually a super corporate friendly place to be, for better or worse. But if you're the one setting up the company, these things are good. Also, we don't have state income tax like other states do. So yeah, let's talk about that. A question that I get asked a lot is, I heard everyone else sets up their companies in Delaware. Should I do that? Or Wyoming or Nevada? Those are the top three that I hear. There might be others, but those are the normal questions. And 99.9% of the time, my answer is going to be no, why would you bother with that? And the reason is you can set up a company in another state. And if you're doing all of the work in Texas, you are still supposed to domesticate here, is what that's called. To file domestication paperwork in Texas is $750. So you're incorporating in whatever state you're incorporating in, paying that fee. And then you're also, if you're doing it correctly, paying Texas $750 to be here. You also have to have a registered agent, which is a physical address in the state that you've set up in. And there are companies that do that for you, but it's just another fee. And there aren't really any benefits to that. The reasons that people do that or think that, the Delaware one is because Delaware has set up their court system to be different than any other state, and it's very corporate friendly and very specific. So if you're American Express and you have 500 different subsidiaries and you have lawsuits every day of the week, it might make sense for you to be in Delaware to take advantage of that court system. But for us, we probably don't need that. The Harris County court system is plenty sophisticated. We have a lot of business here. They're going to understand your business issues. So there's no real reason to take advantage of that. The advantage that I've heard about Wyoming and Nevada is that it's harder to get to the owner's information. I don't think that's going to stick. First of all, I don't know how much you all know about the BOI and the FinCEN stuff that's going on. We'll talk about that in a second. I have it on another slide. But right now, those are not, you're not obligated to file that, but eventually I think it's going to happen where there's a disclosure required for the owner of a company. So in Texas, it is pretty easy to figure out who owns a company. There are ways around that. But for the most part, if you're not trying to hide your identity, I mean, and there are some ways to make it slightly more difficult, there's no reason not to do it in Texas. If you're doing business in Texas, just set up your company in Texas. I don't think there's any reasons that would really sway me as to why somebody should be setting something up somewhere else. If you're doing everything in a different state, set it up there. But if you're in Texas, you're doing the work here, just set it up in Texas. I already said that. Okay, and this goes for everything, including nonprofits. Once you have your entity set up, which again is very fast, you can get a tax ID online for free. If you need a tax ID, you're trying to get an EIN, same thing. Make sure you go directly to the IRS website because there's no reason you can't do this yourself. It's a pretty straightforward form. And there are companies that will come up in your SEO that are like, get an EIN, only $60. You don't need to pay somebody $60 for that. I mean, people pay me to do it, and I'm happy to do it if they just don't want to. But that's the easiest step of this whole thing, is getting a tax ID. So go through the IRS, and it's instant. It gives it to you as a PDF. Make sure you're filing the proper tax return. Yeah, I just mentioned this. LLCs, corporations, and partnerships have to file a public information report with the state each year. That is also very simple filing. It's just, who are your directors / your owners / members? What are their addresses? And you do have to find a code that categorizes what kind of company you are, but that's also easy to find. And that's it. There's no fees until you hit that 2.47 million. The BOI, that's the thing I was just talking about. That's the beneficial owner report thing that just came out this year. Some of you may know what I'm talking about and some of you may not. It's still, even in my like lawyer Facebook groups, there's still some confusion about what BOIs. So it was a thing where you made a federal filing declaring who the beneficial owners of your company are, essentially to get around shell corporations so that people could stop hiding who owns their companies really. But right now, just last week, actually, there was an injunction issued. So right now, those filings are not relevant and not happening. That may or may not change again. Keep your ear to the ground. But right now, you do not have to do that. Make sure you keep all your company records up to date, and then have a retention policy. And this is especially important for nonprofits, actually, of how long you're going to hold on to your documents. It's some stuff you should be holding on to for a long time, like your 1023, we'll get to that. All of your corporate basic stuff, hold on to that forever. But as far as other records go, like financial statements, et cetera, you can set a policy about what that would look like for you. I have 7 years here because that's the IRS's standard, but it can be 10. A lot of companies use a 4-year standard. But as far, like I said, in nonprofits, I think it's especially important to hold on to this stuff because there can be accountability for grants, et cetera, and you don't want to be caught empty-handed if there's some sort of documentation that you need to prove something to qualify for something somewhere. So set a policy, maintain it, but you don't have to keep your bank accounts for 20 years or anything like that. This is a good point for questions on that. I know I've just thrown a ton of information at you, but if anyone has any quick questions right now, this is a good spot for that. Okay, cool. I'll keep talking. Okay, within your company, there are agreements that you do not file anywhere, but that you keep on record to govern your company amongst yourselves. And even if it's just you as a single member LLC or something like that, it's still important to have this because the main reason to have the LLC is really for that liability protection. And if you do end up in court, you want to be able to say, I am operating my company properly. Here's my company agreement. It says I take out money every quarter. That's what I'm doing, just to prove that you're doing everything on the up and up. In a corporation, which includes a nonprofit, those documents are called bylaws. In a partnership, it's a partnership agreement. And in an LLC, it's a company agreement or an operating agreement. And they're all basically the same thing, slightly tweaked for whatever type of entity you have and to use the right title and the right terms for your directors / board members / members. But otherwise, they all do the same thing. It's your internal nonprofit or for-profit governance document. Some of the things you want to talk about in a partnership or an LLC agreement: ownership shares and voting shares, voting requirements on each different type of thing. So some things might just be a majority vote, but maybe you require a super majority, which can either be 2/3 or 3/4, however you define it, or unanimous. So maybe it's just a majority vote to decide what bank we're going to use, but it takes a unanimous vote to decide to shut down the company, something like that. How do you get rid of somebody? How do you add somebody? Capital commitment, that wouldn't exist in a nonprofit, but in a for-profit, how much money is everybody putting up? And service commitments, if they're not putting up money or if they're doing something else, what does that look like? What are they obligated to bring to the table? Distributions, how often do they get paid out? And then what if somebody dies or gets divorced? And the reason that divorce matters is because in Texas, we're a community property state. So if you started a company and you're already married and then you get divorced, technically your spouse has an interest in half of your income from that entity. It doesn't mean your spouse gets to step in and vote, but they would have an interest in that income. So that's something that you can address in a company agreement about getting that interest back to the company or how that will be managed. In the arts world, we have a few other things that we also want to make sure that we touch on. Intellectual property is a huge one. So if, there's obvious things like once the company's already started, if it's generating creative material, then that material probably belongs to the company. But what if you already have things that you're bringing to this LLC? Like, I don't know, say most LLCs aren't going to produce plays, but say you're producing plays and I'm a member of the LLC and I've already written some plays, but we're going to produce my plays in the LLC. Who owns what? Do I still own those rights? What rights does the company have? How are we going to address that? And another big one is the name, which is under trademarks and goodwill. Is this a name that you had before you came to the entity? Do you get to keep it afterwards? Or does it just belong to the company? And if you leave the company, nobody gets to use it. Works for hire. I have another slide about that, but that's a copyright question. So if you're bringing in independent contractors to do something for the company, or if you have employees, what does the company own? Gear and purchases, equipment, and music publishing if we're in the music business. So so far, I've mostly been talking about for-profit entities, but I want to touch on some of these things for nonprofits as well. So intellectual property, work for hire, trademark stuff, and a nonprofit. If you're using grant money to do something through your nonprofit entity, let me back up. A lot of times, as we all know, nonprofits are centered around one person or maybe two people and their ideas and their concepts for art. And then they form a nonprofit and they bring a couple other people in to help them see this through. And that is fine. But the thing that gets convoluted there sometimes is splitting up ownership of things, understanding who has the copyright and whatnot. So if this is a nonprofit and you're getting a grant through the nonprofit to produce a new work, the copyright in that would belong to the nonprofit, not to the individual, because the money is not going to that individual. It's going to the nonprofit to produce this thing. If you are an individual coming into a nonprofit that you intend to produce your works through that nonprofit, again, going back to my play example, it is okay to keep that copyright separate. But if I am on the board of the nonprofit and we are going to produce my play, we need some safeguards in place. I can keep the copyright in that play if I wrote it with my own money and my own time outside of this entity. But when the entity produces it, there should be a contract with me. Ideally, if I'm on the board, I should be granting it, preferably free, but if not, then at least at or below market value. The rest of the board needs to be voting on what that is. I need to be excluded from any of those conversations that are going to benefit me or have to do with my copyrighted works. So there are ways to manage that, but especially in a nonprofit, it can get messy. And the reason why that's so important is because nonprofits have permanent dedication of assets. So anything the nonprofit owns forever, and that includes intellectual property. And if the nonprofit dissolves, they have to then give their intellectual property to another company, to another nonprofit. So you can't just give it back to your founder. So that is a common misconception and something that needs to be dealt with upfront and addressed, because like I said, there are ways to manage that within reason, but it's something that needs to be addressed before anything gets done, so that it's all clear amongst everyone and the board understands what's happening. Don't need that. Okay. Piercing the corporate veil sounds very James Bond. The reason to have an entity is to protect yourself from liability for whatever that could be. I keep using like a physical instance, but it could also be an intellectual property instance. Maybe you get sued because your play is too similar to someone else's play and there's a copyright question here, etc. So how do you keep yourself protected individually? First of all, making sure that every contract is executed in the name of the business, not in your name individually. And that's what this could look like. of course, I made this up. Beyonce is not my client. That would be awesome. But you can see here in my signature that I am signing as partner on behalf of my company. It could also say OBO, which is on behalf of, but in any case that indicates that the contract is not with me as a person, but with my company, and that I'm signing only in my capacity as someone with that company. That's really important to do. Keeping a separate bank account and not commingling funds. So in a nonprofit, I don't think that's going to be a problem. I think most people know that. But where that can get sloppy is if you have an LLC and it's just you, that's your money, right? So if you have a bank account for your LLC, it's easy to just take your LLC debit card to HEB, but don't do that. You can take money out of your account whenever you want to, but take the money out, transfer it to your other account, then go to the grocery. Do not use your LLC debit card for personal things. That is one of the biggest ways people can get around your LLC and sue you personally. Keep your company agreement updated, even if you're the only owner, and keep all of your documents organized so that if you do end up in a situation like this, you can back up everything you're saying. Because it doesn't matter if you signed all those contracts in your company name if you don't have any of the contracts anymore. So within reason, keeping stuff on hand. Did that. Okay, I don't know if we need to talk too much about this right now. Sure, let's do that. And other things that you need to do. And this is an important one for nonprofits too. Do I have a separate slide for this? No, I don't. Okay. Sales tax. No, these are for nonprofits. Okay. So, if you have an entity of any kind and you're selling something, you're obligated to collect and remit sales tax. And this includes nonprofits. We'll get more in detail on that in a minute. But nonprofits being tax exempt does not include the obligation to report sales tax. So doing that. If you do have to apply for a sales tax permit, you have to do that quarterly. Getting any licenses that you need in place. And this is an important one too, between nonprofits and for-profits. There's often a misconception in the nonprofit world that they don't have to do all of the things that for-profits have to do, like get a license to use the music that they're using because they're nonprofit. That is not true. ASCAP does not care if you're a for-profit or nonprofit. So if you're putting on an event and you're using music and you're going to have alcohol, you need to contact the TABC and you need to get licenses from ASCAP, BMI, et cetera, for the use of that music. We don't need to understand all of that right now. The point is, don't make any assumptions just because you're a nonprofit corporation that you don't have to do the things regular corporations do, because most of the time you do. And then whatever insurance you need, that could be D&O, which is directors and officers insurance, general liability. And when you need insurance is something that you can sort of gauge. You know, if you're a graphic designer working at home on your laptop for small-time clients, you're probably okay. If you're holding events where a bunch of children are going to be there in person, you should probably start looking at liability insurance. If you're bringing in giant sums of money or you have very high-profile clients, you should be thinking about general liability and D&O insurance. And if you are putting out creative input like books or movies, you might be interested in E&O insurance. And in fact, a lot of distributors will require that you have that, which is errors and omissions. And it's essentially copyright insurance. I'm dealing with that right now for a film that we just had, that we did all the legal work for that just came out. Okay. So nonprofit corporations, can I ask, sponsored projects, are you mostly not yet nonprofit corporations? Has anyone already filed for to be a nonprofit corporation in general? Don't know.
We're
Okay.
already a nonprofit.
You're already a nonprofit. Okay. Just a nonprofit, not 501c3?
No,
Is
we
that-
are a 501c3
You
too.
are a 501c3. Okay.
Most of them are not yet nonprofits. Some of them don't want to become nonprofits, and then some of them are interested in eventually doing that.
Okay, that's helpful. Thank you. I didn't want to tell everybody stuff they already know. So, so in Texas, well, first of all, there's two separate steps. There's being a nonprofit, which is setting up a nonprofit corporation in the state of Texas. And then there's being tax exempt, which is filing with the IRS to be recognized as an exempt organization. Those are not the same thing, even though we use those words interchangeably all the time, including myself. When I say nonprofit, most of the time I'm talking about 501(c)(3)s, but that's actually not correct. So to be a nonprofit organization in Texas, it's $25 filing fee. Same, you'll go through the Secretary of State's office just like you would for any other entity. And in Texas specifically, and in most states, you have to have at least 3 board members, and they can't all be related to one another. So if 2 of you are related, the third person needs to not be related. And you can have more than 3, but you have to have at least 3. The tax exemption is something you do with the IRS, and that costs either $275 if your budget is under $50,000 each year and you expect it to remain that way, or it has already been under 50 for the last 3 years. Or if you're expecting to go over 50 or you already have, then it's a $600 filing fee on a longer form. To file with the Texas, you also need a mission statement. It should just be like 1 sentence, not your entire manifesto, just a simple sentence elevator pitch of what your entity does. And this is an important note that happens a lot with my clients. So I do a lot of nonprofit formation. I love it. I love paperwork. It's a lot of paperwork. The filing form that the state gives you by default does not have everything that the IRS wants you to have in it. And if you're filing the form easy, the short one, the under $50,000 form, they don't actually get a copy of this document, so they don't see it. But if you're filing the long form, you have to send a copy, and they will kick it back if you don't have that stuff in there. So the additional stuff, I don't have it on here, is you have to include a clause that you will not, there will be no private inurement. So there's no benefit to your directors. That's complicated because of course there's benefit to your directors, but the basic thing is you're not profit sharing with your directors. So you're not allowed to do that. You can't give them assets. You can't let your directors live in the house that your nonprofit owns. There's no direct benefit to your directors. You also have to include that clause that I mentioned earlier about dedication of assets, that you understand that everything the nonprofit owns forever. And when the nonprofit dissolves, it has to give it to another qualified 501(c)(3). If you know who that is, you can list it up front. If you don't, you can just say a similar 501(c)(3) that would uphold our mission or something like that. And you also have to specifically reference section 501(c)(3) and the specific words out of that code that you are using. So 501(c)(3)s, it's a little bit weird in the arts organization because artistic is not actually one of those categories. For artistic organizations, we use cultural and educational. But there's a few other ones. There's amateur sports. There's architectural preservation. I'm getting that wrong, but it's basically that. Literary organizations. So those are, you can find it easily online, but cultural and educational, that's what you're going for. But all of that has to be added to that form in the supplemental section. Otherwise, if the IRS sees it, they're going to kick it back and tell you it's not proper. And revising it is not a huge deal. It's another $25 and it takes a little longer. So it's not devastating if you have already filed and you missed that, but it's easier to do it right the first time. So I'm putting that out there. And it does tell you this in the instructions, but it's still not super clear. So once you are a nonprofit in Texas, if you don't file for exemption, you're just a corporation and you still are obligated to file and pay corporate taxes. That's another step I think a lot of people don't know. So if you're just a nonprofit corporation, but you're not exempt, you have to file taxes. You do have a 27-month period to apply, and then that will be retroactive to your incorporation date, and you will be tax exempt retroactively back to that date if you apply and are accepted within that amount of time. But the sooner the better, back to back. So there's actually lots of kinds of 501(c)s, but most of them are 501(c)(3)s. I saw some statistics on this lately, and I wish I could remember them, but it's a huge percentage are 501(c)(3)s, and then everything else is very small. Some of the ones you might have heard of outside of that, C4s are social groups, things like that. C6s are business leagues. So it could be, if you remember the bar Okra, that was a 501(c)(6). What else? I represented one time that was like a group of energy companies that work together to share resources, like clean energy companies to share educational materials and have a conference, stuff like that. But most of us are 501(c)(3)s, and the reason why is that that's the only category where donations to the entity are deductible to the donor. So all of the other 501(c)(3)s don't pay taxes, but they can't accept money and, well, they can, but the person giving them the money does not get to deduct that as from their income. So that's why the 501(c)(3) category is popular. But you do have to justify that you fit into one of those categories that I mentioned, and you also have to serve a charitable class. Charitable class is a pretty vague term, but in general, you have to show that you can't name everybody that you're helping. So if it's like somebody's cousins or everyone who lives on this street, that would not be a charitable class. If it is underserved children in North Houston, that'd be fine. Or, with arts organizations, we're mostly just saying it's open to the public, anybody can come. That's good enough, but you just can't limit it. I get a lot of calls where somebody wants to set up a scholarship organization to benefit one particular person, or they have a family member who's in the hospital and they want to set up a nonprofit for that person's expenses. That you cannot do. It has to be for a broader class of individuals. So why would you not want to set up a 501(c)(3)? It sounds like some of you don't want to do that, and I understand that. There's a lot of competition, and the more 501(c)(3)s we have, the more we're splitting grant money. So the last number I had was that there were 12,000 nonprofits in Harris County. I don't know how many of those were active, but that's a number. That's a huge number. If you are a 501(c)(3), obviously you can get grants and corporate donations. Consider a fiscal sponsorship. Sounds like y'all already did. And I think this is a big conversation I have with my clients when I first meet with them and I get the impression that they're doing something that there's already somebody doing. Check your ego. Why is it that you want to do the thing that you're doing? Is no one else doing it? Or is just no one else doing it the way you want to do it? Because if that's the question, maybe there's somebody you can partner with to develop a program with them or something like that, or get involved instead of making everybody split the $12 that the rest of us already are sharing after the big entities get their money. So if there's a way to do another thing, sure. And I I'm not trying to be entirely discouraging, but I am trying to be realistic that nonprofits are a lot of work. It is more scrutiny than a for-profit. I think that's a thing that surprises clients a lot, is that it's less time and effort to set up an LLC because the government doesn't really care what you're doing with that as long as it's legal and you're paying your taxes, whatever. But with a nonprofit, there's more scrutiny because you are not paying taxes on that money. So they want to make sure that it's being used appropriately and that you're not just using it as a tax shelter or hiding money in it. So it's more work, it's more effort. There is more ongoing maintenance in a 501(c)(3) than there is in a for-profit entity. But if you need that grant money and those donations, it's the way to go. Quickly, some other options, that some of which we have here and some of which we don't. PLLCs and PCs, you might have seen that. That is for professionals. So like my law firm is a PLLC. So it's just professional limited liability company. It's for doctors, architects, lawyers, people who have to be licensed. So just putting that out there so you understand that terminology. LP is a limited partnership, and that is where you can have a partnership, but instead of everybody being liable, just one or two people are liable, and then you have other people involved, like investors who aren't liable for the missteps of the partnership. These are some that we don't have in Texas right now, which is the L3C, the low profit limited liability company, and a benefit corporation, which is essentially a compromise between the for-profit's obligation to always maximize income to its shareholders, which I think Elon Musk just posted something about that today, and the things that a nonprofit does. So, for example, an L3C or a benefit corporation may have a structure where they are going to run a coffee shop and everyone who works there, all the employees are going to be people who have Down syndrome. So is that maximizing profits to shareholders? Probably not. Is it a purpose that's important to them? Absolutely, yes. So their shareholders in these entities understand that there is something else that they're doing that's important to them that overrides profits, and they're on board for that. It could also be like environmental considerations, hiring ex-felons, et cetera, something like that, where it's a specific thing that they want to do that's possibly not the thing that a traditional company would be comfortable with. And B Corps, not to be confused with benefit corporations, is just a designation. You can get sort of like a LEED certified building. or minority-owned business, where you apply for that. You prove that you're operating your company a certain way, and then you can put the B Corp stamp on your stuff, and some investors and patrons care about that. But that's not a different kind of entity. It's just a stamp that you can get. Some resources to look into stuff, whether it's your own company or you're trying to do some research or find out something about someone else's company. Through the Texas Comptroller, you can look up an entity for free to see if it's in good standing, and you can also file your franchise and sales taxes there. If you go to the Comptroller site, at the top of the page, there's a tax drop-down menu, and if you go to the franchise tax or status account page, then that's where you can search. The Secretary of State site, that's where you file the forms yourself to incorporate, or you can have someone do that. You do need an account, but it's free to set up an account. IRS.gov, like I said, go there directly to get an EIN or any tax forms that you need. Don't go to a third-party site that's going to try to charge you for stuff you don't need to be charged for unless you want to. But just do that knowingly, knowing that that is not something that actually has a filing fee, that you're paying for the service. And that's fine as long as you understand what you're doing. And if you're going to file your own public information report with Texas, you need to find your NAICS code, which again is just a categorization of what your company does. And that is super easy to look up. Sales tax for nonprofits. So again, nonprofits still have to pay sales tax on sales, but you can be exempt from sales tax on purchases. So when you're tax exempt, what that really means is exempt from federal income tax, but there's other taxes you still have to pay and collect. After you get your designation from IRS, you can submit that to Texas and become tax exempt from filing franchise taxes and from sales tax on purchases. On sales, nonprofits are obligated to collect sales tax on sales unless you have 2 tax holidays that you can choose per year. So if you're selling t-shirts all year, you should be collecting and paying sales taxes on those t-shirts. If you are having a big gala and you're going to have an auction and sell items at that event, that can be one of your 2 sales tax holidays and you don't have to report that. So just keep that in mind, that you are supposed to be paying sales taxes on stuff that you do throughout the year. Unless it's one of those holidays, you only sell non-taxable items, or you raised funds only by using a for-profit entity to sell them, which is like, for example, when you're in high school and you go through one of those companies that sells wrapping paper and popcorn or whatever, essentially on your behalf, and you're not the one technically making the sale, then the sales tax obligation is on them. So before, when I first talked to Julia about this, there was a list of questions that came through, and a lot of them were actually copyright and trademark related. And I love that stuff, and I'm happy to go in that direction. So that is why I've made this like Franken slide where we went through entity stuff, and I've also tacked on some IP stuff. So we're going to get through this pretty quick. Copyright in general is these 6 different things. Copyrights are for your creative works. So that could be artwork, photography, paintings, music, literary works, software code, architecture, choreography, anything like that, books that you write, as opposed to your brand names and your brand insignia, like a logo or something like that. That would be a trademark. Patents are for inventions, methods, things like that. And these are often confused. So that's why I wanted to just mention that real quick. I had a lawyer ask me a few weeks ago if my client had patented her movie yet. So, you know, even lawyers at this level don't know always the difference between copyrights and patents. So just wanted to get that clear. But mostly what y'all would be dealing with are copyrights and trademarks. So copyrights, here's a list, you get it. Performing, making derivative works is really the only one I should mention. That is when you take something that already exists and make something new out of it. So it could be, or even a piece of something, or multiple somethings. So it could be translating a book into a new language. It could be Marvel making movies out of comic books. It can be making a mashup of a song or a collage. That's a derivative work. To copyright something, it just needs to be an original work of authorship. Original is a very low standard. It doesn't mean no one ever made this work before. It means you made it yourself and you didn't copy somebody else. So it is possible if you had like a sort of basic, you know, 145 pop song, that it could be very similar to another song that somebody else wrote, and you could both have a copyright as long as you didn't copy someone else or each other. Works is anything I listed, and authorship just means you made that work. It doesn't necessarily mean you're an author, like as in a book. Importantly, you cannot copyright an idea, which is why when one type of movie or TV show is successful, there's suddenly 500 imitators, because you can absolutely do that. You can't copyright the concept of a reality show. You can just copyright your actual product, your dialogue, your song, your lyrics, but that doesn't stop somebody from writing a song or a book or poem about the exact same thing. Who owns a copyright? The obvious answer is the creator or the creators together. If you're just working on something, and you all already have copyrights. If you've ever drawn something, taken a picture with your phone, written anything down, you already have a copyright in that, so congratulations. If you worked on something with someone else, it's a joint work. You can transfer contracts or copyrights by contract or by will. And then works made for hire, I said I was going to come back to that. So this is an important one that's also often misunderstood. Works made for hire specifically means that the person who's hiring you owns the work. There's a lot of misunderstanding about how that comes to be and what it means. So if you are an employee of Fresh Arts, and Fresh Arts, your job is to do the graphic design for Fresh Arts, those works are going to be works for hire for Fresh Arts. You don't own them. You never did. You made them in your capacity as an employee of Fresh Arts, and they own your copyrights in your graphic design. On the other hand, if Fresh Arts calls you as a contractor and says, hey, we want to pay you $500 to design a new flyer for us, and the contract doesn't say anything, then you, the contractor, would still own your copyright in that. It explicitly has to say in the contract that it's a work for hire for them if you're not an employee. So there's a common misconception that paying somebody for something transfers the copyright, but that's not true. There has to be in writing a paragraph that says it's a work for hire. My musician clients get sideways with this a lot, where they've paid a bunch of people to come to the studio or to help them write a song, given them money, and then gone to get a deal somewhere and have to warrant and represent that they own all of the rights. And technically they don't. Just giving the money doesn't transfer the rights. That's the main thing I want you to know about works for hire. Works for hire isn't necessarily a bad concept though. Like in a film, pretty much everything is always a work for hire for the production company, because otherwise, anytime you wanted to do anything with that film, you'd have to go ask 500 people to sign off on it, and that doesn't make sense. So it's a practical thing, but it's just important to understand what those words mean when you see them in a contract, and if you're trying to own something that you're paying someone to do, to make sure that you put them in your contract. So I already mentioned that you already have a copyright in anything as soon as you do it, as soon as you quote, fix it in a tangible medium. So if I don't have a copyright in this presentation that I'm making right now because I'm just speaking into the ether, but I would have a copyright in my PowerPoint because it is written down and saved on my computer. Probably y'all know this already, but I still get this question about mailing it to yourself. The theory behind that was that if you mailed something to yourself and you didn't open it, the postmark would prove the date of creation. But the problem with that is that you already have a copyright just by creating the thing. And most of the stuff we're doing these days is digital anyway, so there's already a timestamp in it. And you already have a copyright. And there are certain benefits of registering your copyright that you get by filing with the Library of Congress. So if you're going to do that, just do that, because mailing it to yourself doesn't give you any more rights than you already had. The reasons to register infringement: if somebody infringes your copyright, you have much better claim if you've registered it. And briefly, what I mean by that is there are statutory damages that you can get. So if you've not registered your copyright, you can sue somebody for what you can prove that you lost. If you have filed your copyright, you can sue them for automatically between $750 and $30,000, and up to $150,000 if you can prove that they knew better. And I don't really like to sue people, but it makes the conversation a lot easier to start with. If you're like, I could sue you for $30,000. What I want is credit or some tacos, or call me next time, or half, whatever it is. It just makes it easier to start that negotiation. The more optimistic reasons: somebody is wanting to find you to license your stuff can find you. And also, it's the easiest one to do. Your copyright lasts for your life plus 70 years after you die. and you only have to register it that one time. So it's cheaper than a trademark or a patent. It's on the record, now you're done. Here's the filing fees. We don't need to get into all these details, but they range from 45 to 85. And the ones that are 85 are for multiple works. So the group work, the GRUW form, you can put up to 10 unpublished works of the same kind together. So if you're a poet, you can put 10 poems on the same application if you haven't published them. And the gram work is for albums. So if you have 20 songs on your album, as long as one person is consistent in every song, you can put all of those songs on the same application for $85. Derivative works, I mentioned that. Someone asked about fair use, so I'm going to get into that just a little bit. Let me see what time it is. Cool, we're good. Okay. So since you already understand that fair use is a thing, I'll just mention licensing quickly. In the United States, currently, we don't have what's called an Orphan Works Act. So if something is not in the public domain, I didn't update this, it says 1927, it's 1928 now, and about to be 1929. We get a year of public domain every year. If it's not older than that, and it's not fair use, then you do need a license. There's no excuse in the US for not having a license. I have feelings about that are not for right now. So fair use, what is fair use? How do we know if we can claim that? Fair use is a defense. It's important to understand that. This is something that we end up talking a lot with clients about as well, that fair use is something that you need to know in advance before you use something, that you're going to be able to shield yourself with it, but it's not something that you can proactively claim. Basically, for fair use to come into play, you have to get sued and then say it's fair use, but you still have to defend yourself. It's a defense to the claim. It's not something you can do up front. But anyway, what is fair use? To determine if something is fair use, and it's not entirely fair. These are the 4 factors that are used, and this is not a checklist, it's a balancing test. So consider these 4 things and weigh them against each other, but you don't have to have all of them for something to be fair use. And I'll also just mention that if you are a documentary filmmaker, fair use is super friendly to you. There's pretty well set standards for that. There is a website, I want to say it's called CMSI is the entity that puts together fair use informational packets that they have in conjunction with people who work in the fields, professors, lawyers, professionals, etc., who come up with these standards. And from my understanding, as far as I know, I've never seen them steer anybody wrong with those standards that they've set. But anyway, these are the 4 factors to determine fair use. And I mentioned filmmakers. Filmmakers, you have fair use. You can use it all day long. It's pretty well set in stone. Musicians, sorry, super hard to claim fair use. It's kind of frustrating how it's not entirely used fairly across different media, and that's just something you have to research. The purpose and the character of the use is the first one. So if you're using it for an educational or nonprofit purpose, it's more likely to be fair use than if you're putting it in a feature film that you're making millions of dollars off of. Again, that is not a determination. Using it for nonprofit does not automatically make something fair use. Putting something in a feature film does not automatically mean it isn't fair use, but that's a balancing thing. The nature of the work that you used, same sort of question. If it's a historical document, more likely to be fair use than if you sample Ariana Grande. The amount that you used. So someone asked, isn't it 30 seconds for film? I get random numbers all of the time. There is no magic amount of seconds or percentage or anything like that that makes something fair use or not fair use. There have been lawsuits in music over 3 notes. What matters is how much you took, and did you take more than you needed to do what you were trying to do? So I'll give you an example in a minute. We'll come back to that. And then probably the most important one is the effect of your use on the market for the original work. So if I use a piece of a movie in my movie, are people not going to go watch the original movie now because they don't have to because I showed the most important part? Something like that. So let me walk you through a quick case that would illustrate this. There was a case where a woman inherited her husband's rights, and he had been an actor in a lot of old horror movies. And a cable channel was trying to make a documentary on horror films and contacted her to license some of these film clips so they could be like vampires from Nosferatu to Twilight. I've not seen it, but that's the gist. And she said no. And their errors and omissions insurance team and their legal team said, no, this is fine, it's fair use, go ahead and do it anyway. So they did, and she sued them. And the court used these 4 factors to determine the case. So they said, okay, you're a cable channel, you're making a documentary, you know, that's fine. It's a documentary, it's a educational thing. The nature of the copyrighted work, well, these were feature films, so not necessarily in the favor of the documentary filmmakers. But here's where things turn around. The amount of the work used. So in this case, they are talking about different horror movie monsters over time and showing just a little bit of each clip. So again, maybe saying like in the 20s, Nosferatu was the vampire of choice. He has these crazy fingernails. Later, vampires became hotter and now they're Edward and they sparkle. You know, so there'd just be like little pieces of videos to illustrate the point that they're making. They're not showing the entire movie, and they're all relevant, also important to the point of the documentary. And then the effect of the use on the market for the original. People are not going to not watch Nosferatu or Twilight now because they saw this documentary. So the cable channel won, the documentary happened, and the person who owned the rights lost because the court said this is fair use. You did not take more than you needed. It was relevant to what you were doing. You didn't just take these clips to draw people to your product. And in fact, people might go watch these, are more likely to remember that these movies exist now because they saw your film. Some things that are always fair use: quotes or excerpts in a review. Parody, which is very specific. You can't just write funny lyrics to a song. It has to be making fun of the thing that you took. So like pointedly referring back to the song itself or to the songwriter somehow, that would be a parody. Reproduction of part of a work by a teacher or student for use in a lesson. And then incidental reproduction, which is things that are in the background. So like if I'm filming the news and there happens to be a band playing on a stage in the background, I don't have to license that song just because it ended up in the news. That's different than if I'm, you know, specifically making a feature film and I'm asking this band to come in and play. That's not incidental use anymore. And another one I don't have on here is government work. You can use government work in your works. I made a song recently where I downloaded a recording from a satellite and incorporated that into my song because I can. So a lot of that stuff, government maps, NASA stuff, is fair use. If it's not fair use, you do need to make an effort to find that person and to license the work from them. Again, there's no legal excuse for not having a license. There's no minimum amount that's exempt. But this is one of those risk assessment things. Like if you're making a movie and you want to use a clip of some obscure film from 1937 and the business that made it is well out of business and everyone who's in it is dead and you can't find anyone, just know that if one of their ancestors does see this and is mad about it and it's not in the public domain, they still can come back and sue you. And it doesn't matter how many phone calls or emails you made to try to find them, you could still be on the hook for that. But again, that's the lawyer answer. The human answer is at some point, you're going to make your own risk assessment. Maybe don't do that with a movie that came out last year, but if it's something where you truly cannot find anyone, copyright lasts a really long time, and sometimes that's just the case. We talked about that. And then someone asked about trademarks, so just quickly on that, and then I'll take questions. Trademarks, again, are for your branding elements. So that could be a name, it could be a logo, it could be a slogan. It's anything that people recognize your brand or your company from, or you personally. Registration for trademarks is $250 per trademark class, which is essentially a category. So for example, bands might register in entertainment services, or they might register for clothing. And those are 2 different classes. They have to be renewed every 10 years and you have to pay a fee every time. Sorry, I'm just reading the comments. Okay, got it. Making sure I didn't miss any questions. So it is more expensive because you have to keep it going. And the first time that renewal fee is like $225. At the 10-year renewal, it's like $500. So it's not cheap. And it's a little bit more complicated than getting a copyright because with a copyright, again, it just has to be original to you. With a trademark, it has to be something that no one else currently has a trademark on that's going to be confusingly similar to the public. And that's why I wouldn't necessarily recommend trying to do your own trademark because that is not always very obvious what they're looking for as far as what would be confusing. So another thing that I get asked a lot is, well, what if I just change the S to a Z? Or what if I make the S a $sign? Or what if I put a space between the words? None of that matters, because if I'm saying a company name out loud, it doesn't matter if the S in Wellspring is an S or a $sign. I'm not going to say, well, $sign pring. I'm just going to say Wellspring. So if the average person would be confused, or be like, no, that's Wellspring with a space between the words, that's not the same company. The average person is not going to realize that those are two different things, especially if they don't know anything about either company. So there are some tricks there. I would recommend working with someone if you're going to do a trademark. There's a lot of resources for that out there. But it can be worth it, especially if your brand name is becoming valuable, or if it's something you might transfer someday, or if you're having issues with people using a very similar name. That can be an effective way to protect it. But it is a completely different animal than a copyright as far as cost, complication, and scrutiny from the trademark office. I think that's my last slide. I'm gonna stop sharing. All right. Any questions? I know there were some more on the list that I don't think I got to, but
I have a couple of questions.
okay, go ahead.
Okay, so thank you for this presentation. I really appreciate it.
Of course.
So my questions are around the two. I just have two main questions. The first is, if I am doing a film and I have hired people to make the music for it,
Mhm.
can we set up a contract that basically says, I'm going to use this for the film and for any promotion of the film. It is yours to use in any other way. Is that something that can be done?
Absolutely. So with that sort of thing, as long as you have a contract for it, you do pretty much whatever you want.
Okay.
But that would be pretty typical. So essentially what you're saying is they can keep the copyright in their work, but you have the right to put it in your film and whatever other uses that you need to do, like promotional material, whatever, for no additional fee. But if they want to put it on Spotify, that's their prerogative.
That's it. Okay,
Yeah.
good. Now, my big question, the biggest question I've been waiting to talk to you about this, because I use a quote in my film.
Uh-huh.
So it's a quote from a poet who's 80 something. I can't find him. Um, but it's like two lines that I wanted to put in the beginning of the film,
Mhm.
um, giving him, attributing the work. But it's the essence of the film. The film is around this whole. So there's that, the actual wording. The essence of the film is this, and in one part of the film, an actor says literally a part of the poem.
When was the poem written?
Like in the 1960s, but I cannot find the actual poem. So I'm working from this little booklet that actually has it in there. I can't find
Okay.
the poem itself.
Okay. So breaking that down, basing a movie around the idea of a poem, depending on how correct or how directly it's tied to that idea. Again, you can't copyright an idea. So, and I'm very oversimplifying here, but if it's a poem about, like, I don't know, space cats, you can absolutely make a film about space cats. But if you're making this movie and it's clearly referencing this poem, and people who know this poem are like, oh, this is obviously a riff on this, I would potentially argue that's a derivative work and something that you would need to have licensed. As far as using a quote at the beginning of a film, that's one of those things that's like, eh, technically something you're probably supposed to license, but also something where that doesn't always happen. It's a
Okay.
little different than using a whole clip of Star Wars or something like that.
Mhm.
So
Okay.
it's one of those things. Again, I can't tell you you have no risk, but I can tell you it sounds like your risk is relatively low if you can't find anyone. And the other thing about copyright that I think about a lot is there's no copyright Santa. Like, someone has to see what you did and then they have to be mad about it.
Okay.
So people treat things differently. Like, there's people who are historically litigious, like Metallica or the Jimi Hendrix estate, who will come after everyone for everything. And then there's other people who are like, cool, you liked my poem, I'm so glad, you know. Uh,
Okay.
so
And then last question on it, is there, like, is it like they could sue you and you lose everything, or is it like they sue you for a portion of this or that, or
So
what's
realistically speaking, you're probably not going to lose everything unless this film becomes like the biggest film of all time. So again, it goes back to whether or not they registered their copyright. If they did not register their copyright, then what they are out is actual damages, which is what they can prove essentially what you should have paid to license this or what they would have charged that's fair for these rights.
okay,
If they have registered their copyright, they could sue you for $150,000, but practically speaking, most things settle.
okay,
So,
okay. Thank you very much. I appreciate it.
yeah, no problem. Good questions.
If I'm filming in Texas, I mean, does it matter? Do I need a Texas attorney, or does it matter where my attorney is licensed?
If you're filming in Texas, technically, so the contracts are going to be Texas-based contracts for the most part.
Right.
Yeah, probably best to have a Texas person doing that. So from our perspective, from the legal perspective, we are not supposed to practice out of state, but that's a blurry line. I mean,
Okay.
in litigation, it's really obvious. Like, I can't go sue somebody in California, of course. But things like trademarks and copyright are federal, so it doesn't really matter where somebody is. When you get into contracts, it gets a little bit more complicated because a lot of times you have one party in one state and one party in another state.
Mhm.
Um, but if everything is in Texas, I think you would want someone in Texas,
Okay.
understanding like Texas contract law and limitations and stuff.
Okay. Okay. Thanks.
Hi, can you hear me?
Yes.
Okay, so I had the question about the fair usage. I just wanted to give you an example of what I was wondering about fair usage.
Okay.
So it's a documentary about a film theater company I ran for about 30 years, and we
Okay.
taped a lot of our shows.
Uh-huh.
And so I'm interested in showing, 7 or 8 minute clips, scenes from some of those shows. So it's not because the documentary is only going to be 70 minutes. So, and we've got 19 speakers. So there's a lot of stuff. So that was really, because someone had said, like you mentioned earlier, that there was maybe a second thing. Somebody had told me less than 10 seconds and it's like
Nope.
fine. So
There's no second thing.
darn. But anyway, so what do you think of taping and these are plays that were produced in New York or London or something. So
So when you say 7 to 8 minutes, do you mean per
not
play?
no 7 to 8 seconds.
Oh, 7 to 8 seconds. Um, so first of all, I just put a link in the chat to the fair use reference that I was talking about earlier. And also, Isabella, I see your question. I'll get to you next. If you're using 7 or 8 seconds of plays in a documentary about that theater company, I wouldn't be too worried about that. The only thing you're getting more complicated in there is that you also have a lot of people who are probably in those videos, and they don't necessarily have rights in that stuff because it's a public performance, and they probably knew it was being archived, etc.
Yeah.
So I wouldn't worry too much about that, because if it's about the theater company and they're relevant to it, and you're diversifying those sources so that those clips are coming from multiple plays and not a lot of chunks from one thing, then that seems probably fine to me. I mean, again, fair use is a scary thing to ever say, but I would feel comfortable with that. So
Yeah, and we wouldn't abuse it either. So
yeah.
also time element. I mean,
Yeah.
we know we can only do a few. So and you answered the thing about the errors and omissions, because that's what I was considering. And then I priced it and was like, wow, that's that's like that could be 50% of our budget. But anyway, so I didn't ask this question because it's actually come up the last week. I'm actually going to do, and it's part of our LLC when we formed it, but I
Okay.
am going to do a book to
Okay.
correspond with the film, the documentary. And I just got a hold of someone that's a ghostwriter.
Okay.
So is it prudent of me to maybe get with you later and see about talking about ghostwriter contracts?
Sure, I can help
Because-
you with that if you want to. So.
Okay, because when I Googled it, it did say you really need to outline everything about who owns what. And if it were to become like a sitcom, then, then it's all kinds of crap.
Yeah, yeah, yeah. Quality control, timelines, ownership, all that stuff.
Yeah.
Yeah.
Okay, Erin, thank you.
Thank you. Isabella, I saw your question in the chat about copyrights and trademarks and IP and choreography. So yes, there is a copyright registration option for choreography. That is something that you can do. As far as registering for choreography, you have to submit, and this is true of any copyright, but specifically in that case, you have to submit a deposit copy, which proves that the work exists. So if it's a book, you'd mail in 2 copies of the book. If it's something you've only released online, you can upload a video or something like that. So with choreography, you do need to have something in order to submit that you did create this choreography, and that could be either some sort of notation or a video of it existing. But yeah, you can have a copyright. Trademark and choreography you probably would not have unless you have a specific brand name that your dance company uses, or whatever capacity you're working in, and you trademark that. But yeah, definitely copyright.
Okay, thank you. It's funny because I was just remembering how I'm not sure if you're familiar with a company called Rosas. Rosas was a pretty famous and still very well-known company. And the director choreographer had made this piece that was a film, like dance film. This was all in like the 90s, I believe. But Beyonce ended up, whoever was the artistic director for this like Beyonce video, basically plagiarized all of this choreography from 2 different pieces that the company had made. And so that's something that I was thinking about yesterday as a topic of interest for today. So I appreciate it.
Yeah, that's a good question. There's actually been several lawsuits about that stuff in the last few years because of Fortnite. And maybe you've heard about some of those, like some of the Fortnite dances and whatnot.
That's so crazy. And what's funny about that is as choreography and dance has become even more accessible through like these social media platforms like TikTok and like doing reels and stuff, I have been thinking about that a lot. I mean, I'm not really interested in doing those things, but thinking about how people might start to claim like intellectual property rights over 30 seconds over
Yeah.
a reel or something. It's super fascinating to watch.
Yeah, and the law has not caught up to that sort of thing yet. So we'll see in 15 years when the law figures out how to deal with social media. Then we'll see then. Jesse, your question, do you need a fiscal year for an LLC? Most LLCs are just on a calendar year. I mean, everything starts on a calendar year unless you elect for a different fiscal year. I've worked with one LLC that had a different fiscal year, but for the most part, if you're not on a grant cycle or tied into schools or something else that has a seasonal aspect like that, I don't know why you would need to, but you can if that's important to you.
No, yeah, thank you for answering that. I just was like always worried. I had worked for nonprofits for years and always was like, we were on the fiscal year, blah, blah, blah. And going into this being LLC/fiscally sponsored,
Yeah.
I just was always like worried I was doing something wrong for not having that.
No, that's more of a nonprofit thing.
Okay, cool.
Yeah, by default, you're on a calendar year. So
Perfect.
all right. Well, y'all had good questions.